Hello and welcome. I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. Thank you so much for joining me here today. Today, I want to talk about a law called the Child Status Protection Act, which is an important piece of immigration law. And so I want to share my screen in order to discuss it in more depth with you here. I'm going to pull up my PowerPoint here, the CSPA training. The date is September 1st of 2020. I will create a little PowerPoint presentation here. All right, here we go. So hopefully this is a useful thing for you. I'll make my talking head here a little bit larger. So my topics to discuss is, first of all, what is a child as defined by the Immigration Nationality Act? All right. What is the Child Status Protection Act, the CSPA? When does the Child Status Protection Act prevent an immediate relative from aging out? When does the Child Status Protection Act prevent a preference immigrant, which is different from an immediate relative, from aging out? And when does the Child Status Protection Act prevent an asylee derivative from aging out? All right. So this will be a short presentation, but I want to discuss it with you, and I want to make it clear today so that you are fully informed about each of these topics. All right. So immigration law in the U.S. defines a child, quote unquote, as a person who is both unmarried and under the age of 21. All right. And if you're the parent, then they are your child, then your relationship as their parent is defined by your being the record parent, the legal, lawful parent of this person. All right. So in other words, basically every relationship in immigration law is based on the relationship with the child. So, for example, the sibling relationship would be two children that have a parent in common. All right. Legally, if the person is married or if they are over 21, they are no longer a quote unquote child, but they might be classified as your quote unquote son or your quote unquote daughter. All right. So that's it's a linguistic difference. All right. But that's the way it works. So a child under immigration law, under U.S. immigration law, has to be a person who is both unmarried and under the age of 21. All right. And so then the question becomes, what's the Child Status Protection Act? So here's the deal. All right. What happens if you are filing a petition? What if you're a U.S. citizen? You're filing a petition for your child who was born in another country. And imagine you filed that petition when the child was 19. And now the petition, imagine, the process takes 2 to 3 years. So imagine that child turns 21 while that petition is pending. Well, what do? All right. Is that person protected? Are they still a quote unquote child? Or now do they have to wait 12, 13, 14 years for the, under a whole different category if they are the unmarried son or daughter of a U.S. citizen, for example? All right. And so that question can stress a lot of people out. And that's where the Child Status Protection Act comes into play. And so I'm just going to read this. This is straight from the USCIS policy manual. And it says, quote, the core purpose of the Child Status Protection Act, or the CSPA, was to alleviate the hardships faced by certain immigrants who were previously classified as children for immigrant visa purposes, but who, due to the time required to adjudicate petitions, turned 21, all right? And therefore, theoretically, were ineligible to receive such visas. So what this section does, sorry, I'm just gonna keep reading here. Section 101B1 of the Immigration Nationality Act defines a child, as we just saw, as a person who is unmarried and under 21 years old. The Child Status Protection Act does not alter that definition. Instead, the Child Status Protection Act provides methods for calculating the immigrant's age for immigrants' visa purposes, all right? The resulting age is known as the alien CSPA age, all right? The CSPA does not change the requirement that an immigrant must be unmarried in order to remain eligible for classification as a child for immigration purposes. Hopefully all that was clear. It'll maybe be cleared up as we go through these next categories here. So my next question, and really one of the key questions, is when does the Child Status Protection Act prevent an immediate relative, all right, if you're a US citizen and you're filing for a minor child, they are a quote unquote immediate relative, from aging out? And so if the applicant was under the age of 21 and unmarried at the time of the filing of that petition, the I-130, for example, and if the applicant remains unmarried, then they're good. Okay? So for immediate relatives, their ages freeze at the time of the filing of the I-130. And so that's great. As long as that petition was filed before the immigrant turned 21, they will be protected if they're an immediate relative. So what's an immediate relative? Immediate relatives are spouses of US citizens, children under 21 of US citizens, parents of US citizens, all right? They are not the people that are listed on the visa bulletin, all right? Which people listed on the visa bulletin are children of United States, or sons or daughters, I should say. Unmarried sons or daughters of United States citizens is category F1. Spouses and children of green card holders. So if you have a green card and you're petitioning for a minor child, they're not an immediate relative. We've got to look at the next category. All right. So anyway, if they're an immediate relative, basically you got to file that petition before the child turns 21, and the child has to remain unmarried throughout the whole process. And if you got those two things, then great, they'll be protected from the Child Status Protection Act. All right. The next one is the more complicated one, and this is, when does the Child Status Protection Act prevent a preference immigrant, not an immediate relative, but a preference immigrant, from aging out? So here, we've got to get out the calculator, and we've got to figure out what's the age at the time of visa availability. I'll kind of put my mouse right by it here. What's the age at the time of visa availability? And we have to subtract the time that their petition was pending. And that's where we will calculate their age. Okay, so the example here is the applicant. Imagine the applicant is 21 years and 4 months old when an immigrant visa becomes available to him or her. In that situation, the applicant's petition was pending for 6 months. And so their age, their CSPA age, is calculated as follows. 21 years and 4 months minus 6 months equals 20 years old and 10 months. So therefore, their age is under 21, and therefore they're still a quote-unquote child, as long as, and this point is true, they have to still be unmarried throughout the process. And there's this additional requirement that the applicant has to seek to acquire their lawful permanent resident status within 1 year of visa availability, or they can argue extraordinary circumstances if they were unable to seek to acquire during that time. But if they do all that stuff, then they'll be protected as a child, and that will save them years and years and years of a delay process, because children are a quicker category across the board than adults are. Okay, hopefully that was helpful. If it wasn't, or if you've got questions about your case, please feel free to contact our office. So now we're going to look at it for asylee derivatives, all right? So now imagine that your mom filed asylum and you're 19 years old, and you know, asylum cases can take years. So now the question is, are you going to be able to still be a derivative on your mom's asylum case, even if you're over 21 when her asylum case is approved? All right. And so here's the rule. The applicant must have been under the age of 21 and unmarried at the time the principal asylum applicant's Form I-589 was filed. All right. So as long as they filed asylum while you were still a minor, while you were under 21, And 2, you've got to remain unmarried all the way through the time that you seek adjustment of status. So it's not just enough to get asylum status. You've got to also go for your green card before you get married. All right. And if you do those things, you can adjust status as an asylee derivative. That's it. That's all I wanted to say to explain the Child Status Protection Act. This is complex. There are lawyers that don't even know this. They should know it, but there's a lot of lawyers out there that get confused with it. And so if you are a child going through an immigration process, or if you're a parent and petitioning for a child, you'll want to understand, if they turn 21, what happens? If they turn 21 during the process, are they or are they not going to be protected by the Child Status Protection Act? If you have questions about it, please don't hesitate to contact our office. We do know what we're doing, and we can help you navigate this issue. And yes, it can be a complex area of law. And so, you want to really look it over carefully and make sure that you know whether or not you're going to immigrate, all the children that are involved in the process, or some, or whatever. And yeah, I hope this was helpful. Thank you so much for watching this. I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. Thank you. Bye-bye.